5 seconds to go. Start. This court stated that narrowly interpreting the phrase to mean a disqualification of a mother to act as a guardian during the lifetime of the father, would have made the section unconstitutional for violating the constitutional prohibition against discrimination on the grounds of sex. Stop. Para. The object of section 32B of the MTP Act, read with Rule 3B, is to provide for abortions between 20 and 24 weeks, rendered unwanted due to a change in the material circumstances of women. Stop. In view of the object, there is no rationale for excluding unmarried or single women who face a change in their material circumstances from the ambit of Rule 3b. Stop. A narrow interpretation of Rule 3b, limited only to married women, would render the provision discriminatory towards unmarried women and violative of Article 14 of the Constitution. Stop. Article 14 requires the state to refrain from denying to any person equality before the law or equal protection of laws. Stop. Prohibiting unmarried or single pregnant women (start) whose pregnancy are between 20 and 24 weeks (close) from accessing abortion while allowing married women to access them during the same period would fall foul of the spirit guiding Article 14. Stop. The law should not decide the beneficiaries of a statute based on narrow patriarchal principles about what constitutes permissible sex, which create invidious classifications and excludes groups based on their personal circumstances. Stop. The rights of reproductive autonomy, dignity, and privacy under Article 21 give an unmarried woman the right of choice on whether or not to bear a child, on a similar footing of a married woman. Stop. Para. In view of the purposive interpretation accorded to Rule 3b, we are not required to adjudicate upon its constitutional validity. Stop. Para. Article 51 of the Constitution requires the state to foster respect for international law and treaty obligations in the dealings of organized people with one another. Stop. The Protection of Human Rights Act 1993 recognizes and incorporates international conventions and treaties as part of Indian human rights law. Stop. International human rights norms contained in treaties and covenants ratified by India are binding on the state to the extent that they elucidate and effectuate the fundamental rights guaranteed by the Constitution. Stop. Para. Article 6 of the International Covenant on Civil and Political Rights recognizes and protects the inherent right to life of all human beings. Stop. The UN Human Rights Committee has remarked that, in terms of Article 6, state parties have the responsibility to provide safe, legal, and effective access to abortion. Stop. Further, it was suggested that state parties should disseminate quality and evidence-based information and education about sexual and reproductive health to prevent stigmatization of women and girls seeking abortion. Stop. Para. India has also ratified the International Covenant on Economic, Social and Cultural Rights, which enumerates in detail the right to mental and physical health. Stop. The Committee on Economic, Social and Cultural Rights in their comment on Article 12 of ICESCR has observed that the right to sexual and reproductive health is an integral part of the right to the highest attainable physical and mental health. Stop.